Well, welcome everyone, and thank you for joining us for today's webinar, Business and Legal Pitfalls of the SEC's Proposed Climate Disclosure Rules. Along with our expert panelists, we will provide an overview of SEC Proposed Rule S7-1022 regarding climate risk and discuss likely compliance outcomes and strategies to navigate them, along with potential legal challenges the regulation may face. My name is David Wayne, and I'm a partner in Saul Ewing, Arnstein & Lehr's litigation and real estate practices, and will be acting as a co-moderator for today's program. I'm joined by Paul Colgan, my co-moderator, who will introduce himself and our distinguished panelists. Paul?
Thank you, David. My name is Paul Colgan. I'm the government affairs person for the Home Builders Association of Greater Chicago. And I want to thank David and the Saul Law Firm for co-hosting this event with us. This is a very important topic, and I appreciate everyone who's here today to join us. And our panelists will be Justin Danilewicz, who's a partner at Saul Ewing, Arnstein & Lehr's Environment, Social, and Governance Practice. Justin draws upon his trial and investigative experience as a former federal prosecutor to zealously defend individuals and entities facing civil and criminal enforcement actions, conduct of internal investigations, and respond to whistleblower complaints and false claims, quitam suits. Justin is ranked in Chambers USA for both 2022 and 2021. He is also a vice chair of Saul Ewing's appellate practice. Dr. Spencer Robinson is our second panelist. He's a professor and director of real estate in the departments of finance, law, and entrepreneurship with Central Michigan University. And our final panelist is George Sullivan, senior principal and CEO of Net Zero Analysis and Design Corporation. George leads the Net Zero Analysis and Design team, a leading environmental management auditor group specializing in corporate carbon footprinting for scope 1, 2, and 3 emissions, emission target setting, carbon footprint reduction planning, and corporate carbon offset project generation. David?
Yeah, thank you, Paul. So before we begin, a few housekeeping announcements. First of all, for Q&A, questions can be submitted through the Q&A tool at the bottom of your screen. While we'll do our best to answer all questions submitted during the webinar, should we run out of time, we will follow up individually via email. Secondly, for CLE, today's program has been approved for distance learning CLE credit in Delaware, Florida, Illinois, New Jersey, New York, and Pennsylvania, with applications pending in Minnesota and Virginia. As a CLE provider, we must be able to verify your attendance. Therefore, at random points during the webinar, we will display and verbally announce 2 numeric reporting codes that you must record and report back to us using the CLE survey that you received in your webinar reminder email, and will also open automatically in your browser at the completion of the program. We will in turn send you your certificate of attendance once we receive your survey response and the CLE has been processed. Please be sure to respond to the Saul Ewing CLE survey with your numeric codes within 5 days of the program. Also, following the webinar, you will receive a follow-up email that will include links to the webinar recording and supplemental presentation materials. Finally, it wouldn't be a presentation with lawyers if there wasn't a legal disclaimer. So the provision and receipt of the information in this program is not legal advice, does not create a lawyer-client relationship, and should not be acted on without seeking professional counsel who have been informed of the specific facts. Paul?
Okay, thank you. And for the Illinois architects and engineers and others from other states who can self-report, reach out to me after the program and I will assist you in getting a certificate of completion that you can use in self-reporting. All right, at this point, we're going to have 3 presentations, first by Dr. Spencer Robinson, then by Justin Danilewicz, and last by George Sullivan. And so we're going to start out with a summary of SEC proposed rules by Dr. Spencer Robinson. Spencer? Spencer, you're muted.
Yes.
There we go. Am I unmuted now?
Yes, you are.
All right. Thank
You
you
were
to
lost
our
in the Michigan woods there, Spencer.
thanks to our host, Sullivan Ernstein, and to all of you for taking time out of your day We're going to start by giving an overview of the SEC proposed rule S7-1022, Enhancement of Climate Disclosure. The big picture of the rule is it proposes that firms must disclose climate risk. We can disaggregate climate risk into two large components. The first is transition or GHG risk, and the second is physical, which we can look at in terms of acute or chronic risk. Transition risk is the notion that as physical assets begin to have higher and higher GHG levels, and at the same time, public requirements of lower GHG levels are required or mandated by either public pressure or by regulation, that they become obsolete. Under the transition risk, all firms must report Scope 1 and Scope 2, all public firms. Scope 3 reporting will be for all firms except small reporting companies. There's a little bullet which explains that. And in a minute, if you're not real familiar, I'll give you a high-level overview of what Scope 1, 2, and 3 mean. Importantly, these GHG reports must have external attestation. That means just the same as your financial report requires a third-party audit by a qualified auditor, so too will your GHG reports be required to have a third-party audit by a qualified GHG auditor. Further, every firm will be required to report the physical risk of every physical asset that they own. And that delineates into acute, which is a hazard event, so think a hurricane, a flood, and chronic, which is the effect of long-term change. Scope 1, 2, and 3 will briefly define at a high level. This is a picture from the EPA. Scope 1 is generally considered emissions that your firm creates. Maybe it's from direct manufacturing, maybe it's from a landfill. It is emissions that you actually create from your firm. Scope 2 is basically energy that you use. So the electricity that your building uses, the purchased heating and cooling. Anything from there is pretty much falls in the Scope 2 bucket. Scope 3 is the most challenging to understand at this point in the cycle. Scope 3 involves your entire value chain. So if your firm produces a certain widget, all of the component parts that go into that widget will be part of your Scope 3 value chain. The transport it took to get there, the actual construction of the device itself. Since Scope 3 is a little bit difficult, and if you think about a firm like a Target or a Walmart, one of the major retailers, they're going to have to report in Scope 3 for a wide basket of products. Although there is going to be a push, is currently a push, for their vendors to start producing EPDs, environmental product disclosures, so they can better understand the Scope 3. There is an acknowledgement by the SEC that this is going to be a little bit of a messy process involving some estimation for at least a few years. So long as a firm is reasonable, discloses all material facts, we understand there will involve some estimation, some assumptions. So while a firm can be liable for misstating their Scope 1 and their Scope 2, so long as they are reasonable and disclose everything, they will not be held liable for Scope 3. In other words, if Target or Walmart discloses the Scope 3 of a certain product and 2 years later, they realize, hey, we overstated this product, they can't be held liable for that because it is new information. However, any fraudulent statements, an untrue statement of material fact, a purposely misleading statement, that can still be held liable. There are a number of changes in the market, and I put one example here at the bottom. I briefly mentioned EPDs, environmental product disclosures. One example is the GSA, the General Services Agency, which is the agency that handles all government-owned and leased real estate, in March, required every concrete and asphalt manufacturer to have an EPD so they can start having carbon neutral concrete and asphalt. I would fully expect this trend to continue. The rule very clearly, the proposed rule, outlines what firms are supposed to do. You're supposed to report your Scope 1, 2, and 3, but it has virtually no information yet as to how we're supposed to do that. In the comment period, a number of people, including myself, there's a editorial in the Journal of Sustainable Real Estate, which is a journal I'm an editor at. You're welcome to go take a look about how we should do this. In the center of this picture is ISO 14064. I fully expect ISO 14064 to be one of, if not the only, reporting mechanism allowed by the SEC. Up on the two other corners are BSI's PAS 2060. That is the British Standard Institute's version of ISO 14064. Currently, the corporate greenhouse gas protocol is accepted by most major ESG platforms. There was a Wall Street Journal article about a month ago that indicated corporate GHG is in the process of realigning and restating a number of its standards. Our guess is to align it back into ISO. It was at one point. We can't with certainty say that, but that is the guess. On the bottom of this slide, you can see the Equator Principles and the UNPRI, or Principles for Responsible Investment. Back in March, last March, a year ago, the SEC put out a risk statement regarding ESG. This push towards climate is likely the first push on this ESG platform. There will be more likely next year. The two standards that they specifically highlighted in the risk statement were the Equator Principles, which is a little more focused toward financial institutions, and for real estate institutions, this would be a good fit as well, and then UNPRI. Importantly, we are being told that moving forward, in order to qualify for SDG, Sustainable Development Goal 13, climate action, firms will likely need to report into the Climate Neutral Now initiative, which is mostly ISO aligned and certainly accepts ISO 14064. Before I go on, many of you may have noticed a CLE code at the bottom of the screen, 13721. Those interested in getting the CLE credit, make sure and write this down so you can note it later as you submit your survey. Why do I think ISO 14064 will be likely? There are a few reasons. It is the only globally accepted GHG standard. It is specifically approved in Europe, Japan, Australia, Singapore. It's approved here in North America and Canada and Mexico as accepted. The UNFCCC Climate Neutral Now initiative accepts it. Importantly, one of the stated goals of the SEC in developing this rule is to minimize the reporting burden for firms. Of the S&P 500 firms that report, 2/3 of them already use ISO 14064. Excuse me. And roughly half of the S&P 500 has subsidiary firms that are considered for it. For these reasons, it's almost certain that 14064 will be at least one of, and if not necessarily the only one. When do you have to do this? For accelerated filers, you have until fiscal year 2024 if a $75 to $150 million float. For large accelerated filers, the larger firms, it begins in fiscal year 2023, which is right around the corner. Although you don't have to report until 2024, firms will have to start measuring, baselining, and having all of that data throughout the 2023 calendar year in order to report for 2024 financials. In fiscal year 2024, that external attestation will be required to have limited assurance, a lower standard. Essentially, we've looked at it, we've done a cursory review, it looks okay. And then by 2026, they'll be required to have a reasonable assurance level, which requires a more detailed and thorough analysis of the data that firms are reporting. The SEC is also requiring GHG to be reported in two distinct ways. First, the SEC would like you to report all of your GHG output using your local grid without considering any renewable energy certificates, RECs, or carbon offsets. So the first reporting set is your actual carbon footprint, not considering renewable energy credits, RECs that you purchase, or carbon offsets. Then, separately, these can be reported with your RECs and your offsets. Now, George is going to talk in more detail later about RECs and offsets, but briefly, a carbon offset is carbon that is either removed from or avoided from being put in the atmosphere. It is important that a carbon offset is registered with a UN compliant registry. It is aligned with a clean development mechanism or a CDM, and that it is properly and legally traded. The voluntary market for carbon offsets has not been very well enforced in terms of the regulation. So caveat emptor as you are buying any of these carbon offsets from an unregulated voluntary market. Similarly in the RECs, in order to have a renewable energy certificate count, it should be tracked. You should be able to identify where it came from, the asset that it goes to. And we've identified a number of issues in the market where the tracking is not at a level that will withstand regulatory rigor. Let's move from transition risk to physical risk. Physical risk we categorize into these two components. Acute risk, which is event-driven weather events, hurricanes, floods, tornadoes, wildfires, etc. Chronic risk, which is longer-term weather patterns and related effects, sustained high temperatures, sea level rise, drought. All of these are going to have to be reported for every physical asset, starting again with the 2024 calendar year. Many of you may be familiar with ASTM. ASTM puts out the ASTM Environmental Phase 1, which typically any commercial property will have with a loan to facilitate a CERCLA innocent landowner exemption. The ASTM Property Condition Report is another common ASTM standard. ASTM is also developing a property resilience assessment. I'm fortunate enough to be part of this ASTM team. I'm personally focused on the stage 1. There'll be a stage 1, 2, and 3. And where we're focused there is on transparency. There is a lot of variation in the physical risk assessments that you will get. There's a related project that I have the honor of working on with ULI, the Urban Land Institute, where we have interviewed a number of institutional developers and a number of climate risk providers to talk about how firms are using this data, where the gaps are. And I can tell you, there's a lot of really smart people doing fantastic work in the physical risk space, but the science is new and it hasn't converged yet. So really, when you start to get these, it's imperative you understand the data that you're getting and what it is actually telling you about your physical asset. Because what you'll have to report is where there's any material risk and where you have any opportunities. Specifically, it highlights a few areas. Water, you're gonna have to report if water usage, if you're pulling any water from a region, you'll have to report the percentage that you're pulling. Does changing water supply impact your business, oil, manufacturing, agriculture, etc.? Excess heat. Does excess heat mean there's regional migration from the area? Does it mean increased energy demand, and can your facility support that? If you have any coastal property, sea level rise will be something you will have to start reporting, because we know that sea level rise is occurring. What are the risks to your coastal property? You will have to start reporting what the cost of any actual hazard is, and then what the cost you have of preparing for these hazards, the resilience measures that you're putting into your physical assets. You can see this picture. This is just in 2021, what the billion-dollar weather climate disasters were from NOAA. You can see there are quite a few of them. There's a lot of information here. I'm going to pass this along now to Justin, who's going to talk about some of the legal ramifications of this proposed rule.
Terrific. Thank you so much, Spencer. And it's a privilege to be on this panel with you and George today. To just level set at the beginning, everything that Spencer has just mentioned to you, I want to make sure it's understood, is part of the proposed rule, right? So much of this hinges upon the eventual adoption of the rule, assuming it gets adopted. And that's a little bit of what I'd like to speak with you about in a couple of moments here. So I will be focusing on current market disclosure practices, which we know a fair amount about, the compliance burden that we can anticipate for companies subject to these required disclosures, and attestations, as Spencer mentioned, and then anticipated litigation hurdles, of which there are definitely a number. So, okay, great. Current market disclosure practices. This is data straight out of the SEC's rule proposal. Quite interesting. What they did is they searched public company disclosures, and here I'm focusing on both domestic 10K filers and foreign 20F filers. Canada's 40F form is logged in as well for Canadian companies. And they took a look at certain keywords or phrases that appeared in the disclosures, phrases like climate change, climate risk, global warming, things like that. And based upon those references, they just analyzed the percentage of them that sort of seem to be cognizant of climate-related risk. And as you can see, about a third of domestic filers, 31%, had some kind of reference in that regard. Slightly higher percentage of foreign filers, but on average, a total of about a third, again, 33% of companies are making some kind of reference. Now, in fairness, the obvious critique here would be, well, does a passing reference to one of those phrases necessarily mean that there are really robust climate disclosures being made? Of course not. It's somewhat of a crude instrument, but nonetheless, it gives you an idea of the state of sort of awareness, at least at a minimal degree at this stage. All right, so the next slide here is about disclosure percentages varying amongst different industry participants. Actually, I think I skipped a slide, having a little bit of difficulty, I'm sorry, with the clicker. Let me go back just a moment. This is large accelerated filers who are disclosing the same kinds of terms. And as you can see, it's definitely a substantially higher percentage among that group, 49% of them, whereas the total market average, again, is 33%. All right, so moving on, this is sort of an industry breakdown. Again, you can see at the bottom of the chart on the left, the table, average amongst all filings is 33%. And I just drew a red bar for that average and everything above. The industries that are most prominently disclosing, at least again, judged based upon these keywords and key phrases, are maritime transportation, electric services, oil and gas, unsurprisingly, steel manufacturing, rail transportation, paper and forest products, insurance companies. These are all companies who have obviously been aware of the issue for some amount of time and have been dealing with it, and may actually already have some kind of regulatory requirement to make disclosures, either due to other agencies that they are subject to, and so, you know, are naturally carrying that over into SEC filings. Let's talk a little bit about compliance burden, anticipated compliance burden. As part of this rulemaking process, the SEC is required by law under the Paperwork Reduction Act to estimate the burden that this is going to impose upon public issuers, filers of reports. And so that data is helpful to analyze. I'm not going to go into a ton of detail here, but as you can see in this chart, and this is an estimate of paperwork burden for small reporting companies and non-small reporting companies, focusing only on those domestic companies though. And on the left side, in the second column from the left, there are the different kinds of disclosures that would be required in the event that the rule is accepted, right? So you have climate-related disclosures regarding to governance strategy and risk management. There are financial statement metrics under the proposed amendments to the rule that will be required as well. And then GHG emission metrics and targets, as Spencer referenced. And so when you carry those numbers through, what you find is that the estimated Paperwork Reduction Act burden hour effect per registrant is about 3,363 hours. If you put that in terms of, an 8-hour day for the average person over time, that is at least one full-time equivalent employee, and then some, a little bit more. That is, and then when you consider, over time, the impact of this as you take it out from the 2 to 6 year time frame, and then the 6-year average, it's at around 3,000 hours per filer. All right. Taking a closer look at the incremental financial burden for the industry, meaning all small reporting companies and non-small reporting companies, but again, focusing on domestic companies only. The SEC took a look at just over 8,000 10K filings, and amongst those 8,000 10K filings found that the total burden hour increase across the industry would be 28 million hours. Again, that's roughly 3,000 hours per filer, as mentioned previously. And that's broken down into both internal hours, meaning within a company using its existing human resources, and external professional hours that would be needed as well. I've broken those down. Then there are the climate-related financial statement metrics assurance costs, as Spencer referenced earlier. Assuming the adoption of the rule in some fashion, at least in its current iteration, it's going to require assurances by outside auditors or their equivalent. And that assumes about $15,000 per filer, with a total of about $127 million across the industry. With respect to greenhouse gas emissions assurance costs, about $50 million. That's for accelerated filers, and then with respect to large accelerated filers, substantially more, about $320 million. Okay, let's switch gears to talk briefly about anticipated litigation hurdles. And here I do think that they are going to be substantial. To be clear, this does not mean that there won't be an adoption of the rule in some fashion. I do think that the writing is on the wall, if not yet on the books, for this to become a reality. But precisely how it comes together is unclear, and the opposition is going to be significant. To give you an example, Hester Pierce was the one dissenting. Commissioner Pierce is a President Donald Trump appointee. The title of her dissenting statement, to give you a bit of the flavor, was, "We are not the Securities and Environment Commission, at least not yet." It's a pretty interesting dissent. I recommend it to you if you have an opportunity to read it. She focused on a number of challenges that could be brought. And as other people have observed, sort of outlines a real framework for a significant legal challenge, but I focused on just two here, one being statutory challenges and the other constitutional challenges. With respect to the statutory challenge, the argument would be that the Commission has limited statutory authority to propose rules, that it has exceeded its authority. Regulations, SK and SX, SK being the disclosures relating to greenhouse gas emissions, scope 1, 2, and 3 as referenced earlier, and SX relating to disclosures that apply to financial statements in a footnote that would be required if adopted. And then there's the constitutional challenge that would the flavor of that would be that essentially companies are being compelled to utter certain statements by the government, and we'll talk about that in just a moment. There are a number of entities that have sort of made comments either subsequent to the March 2022 announcement of this proposal or before, because recall that more or less a year prior to that, in March of 2021, excuse me, then Commissioner Allison Heron-Lee had solicited comments from the public about what was then the possibility of a future rule proposal. So the House of Representatives, a Republican caucus committee on oversight sent a letter to Chairman Gary Gensler and was pretty vociferous in their opposition. There have been others. A group of attorney generals, about 16 state attorneys generals led by Attorney General in West Virginia, a number of think tanks, American Enterprise Institute, typically right-leaning think tanks, I think, at least from what I've seen, it would be fair to say, the Cato Institute, etc. Excuse me. Considering for a minute what the flavor of the statutory challenge could be, bear in mind that the statutory authority for the SEC to adopt rules and regulations is, quote, and I have it here on the slide, as necessary or appropriate for the proper protection of investors and to ensure fair dealing in the security. So some say, specifically those 16 state attorney generals that I mentioned, unless the purpose of the regulation is to address fraud on the market, then it does not have a proper purpose. It's not an authorized act of rulemaking. Importantly here, and I think that this will play out in future litigation, there is actually no explicit congressional authority, or let me put it this way, enabling legislation that sort of orders the SEC to come up with the proposed rule. And that's not for lack of trying. There is a proposal that was adopted by the U.S. House of Representatives in June of 2021. It's now in front of the United States Senate. It has been languishing there for about a year now. And so I think it's an interesting thing to observe that despite the effort to bring about that legislation in the United States Congress, the SEC went forward nonetheless to issue its own rule proposal. Commissioner Pierce, in an aspect of her dissent, noted when an agency claims to discover in a long extant statute an unheralded power to regulate, quote, a significant portion of the American economy, we typically greet its announcement with a measure of skepticism. We expect Congress to speak clearly if it wishes to assign to an agency decisions of vast economic and political significance. So, that gives you some idea of where at least some of the challenge is going to come from. It will undoubtedly point to the fact that Congress hasn't authorized this, at least not specifically enough. And Commissioner Pierce, in her dissenting statement, did have some material to work with, relying specifically on Justice Gorsuch, who, is well known in terms of his views of limited agency authority. Specifically, she cited two of his opinions. One, Gundy v. United States, a 2019 dissent from Justice Gorsuch, actually had to do with a completely unrelated context, SORNA, sexual offender registration. But the point there was that even with congressional authorization, Justice Gorsuch said, under the non-delegation doctrine, Congress cannot authorize an agency to take over legislative powers, right, that are assigned to the legislative branch. And so if that's the view where there even is explicit legislative authority, I think that foreshadows a certain skepticism that Justice Gorsuch and others will have about the statutory authority of the SEC to make this particular kind of rule. There's another opinion that was cited. This, as people may remember, involved OSHA's national vaccine mandate, which required employers with 100 or more employees to require the vaccination of those employees or weekly testing at their own expense. The court struck that down. The United States Supreme Court said that absent congressional authorization, the agency, in that case OSHA, was not empowered to undertake that kind of rulemaking in an area that had such profound economic and social consequences. And I do think that we might be heading in that direction when it comes to the court's review, inevitably, of the SEC proposal. Again, not to say that it won't happen, that it won't be approved in some fashion. I think that's probably likely at some point, but I think the timing and the exact nature of it is a little unclear. Finally, very quickly, there's a potential constitutional challenge to the rule proposal, that being under the First Amendment. I think there is some precedent to draw upon here, namely the conflict regulation disclosure that was part of the Dodd-Frank Act. There again, we had a situation where it was authorized by Congress. Notwithstanding that, the Supreme Court found that the requirement to have companies disclose that certain minerals they had obtained from the Democratic Republic of the Congo, the DRC, were not DRC conflict-free, was a violation of the First Amendment. The court said that although the government had a sufficient interest in requiring that kind of disclosure, it wasn't sufficiently narrowly tailored to achieve the objective of lessening the human rights crisis in the DRC. And I think we could potentially see similar language in this case where, despite the appropriate government interest on the part of the SEC to provide, as is repeatedly said in the rule, comparable, consistent, and reliable decision-useful information, whether that is ultimately successful and sufficiently narrowly tailored to achieve the objective, and whether the cost burden that's involved here is acceptable in light of the Administrative Procedures Act, the APA, I think is up for debate. Before moving on, the CLE code number 2 is 53201. It's on the bottom of the slide. Again, CLE code number 2 is 53201. And with that, I'll hand it over to George.
Great. Thank you guys for allowing me to join you in the discussion. Let's go ahead and take a look at some slides. And I'm going to focus primarily on consumption-based RECs in the United States. And we're going to look at carbon offsets. Those have been the two major items in our audits that people have had issues with. So if you can follow along with me. And I seem to have a control issue, unfortunately. I cannot advance the slides. So if somebody could pass me control, that would be good. There we go. Now I've jumped just.
Hey, George, you just need to request the controls from me.
Okay. Got it. There we go. Let's see if this works.
I did not seem to get it, George, but I can control your slides for you if you want me to.
Sure. So next slide. So let's take a look. There are two items that we are definitely going to focus on here. One is the Renewable Energy Certificate or credit or REC. And what a REC is it's 1 megawatt hour of power, renewable power that's generated. The utility actually generates the REC when it crosses the utility meter feeding into the grid. And these are for megawatt hours that are grid fed. There's also megawatt hours that are behind the meter fed. And that is a little bit different discussion because you actually own those because the system is not going through the utility. These are market-based RECs. So in other words, Texas is a market, Illinois is a market, Indiana is a market. Those are market-based RECs. And what we are finding is that a number of the market-based RECs are going through several different venues and being resold, but the issues wrapped around them, and next slide, please, is that the RECs are not being properly accounted for, nor do they meet the requirements of the Nerc Fert grids. So we're going to talk specifically about that And then what is a carbon offset? A carbon offset is 1 metric ton of CO2 not released or sequestered. So they are not interchangeable. One is usable globally, and the other is only usable within the Nerc grid here in the US. So there are your primary differences. Renewable energy credit allows you to reduce your electrical consumption to 10 grams per kilowatt hour versus utility here in Chicago being 520 grams per kilowatt hour. But it is not equal to zero. Next slide, please. So, and this is basically from the EPA describing both a REC and an offset and what you can and cannot claim and or do with those. So we have an article coming out shortly that gets further into these details on what you can and cannot claim, and also too, explaining the Nerc grids, and especially Green E, as we found, is a major issue for people who are buying those. Next slide, please. So back to Spencer's scope 1, 2, and 3, right? We're primarily looking at your scope 2 when we talk about RECs. Scope 3 and scope 1, or scope 1, 2, and 3 can all be offset with carbon offsets. So RECs are very, very specific on that scope 2. Next slide, please. So let's just talk about corporate GHG. There's been a lot of discussion wrapped around, is the US a single market, or is it a multitude of markets? And we actually looked at this in fine detail. The US is not a single market. My utility bill, it comes from Commonwealth Edison here in Chicago, and the state regulates it. That is the definition of a market. So versus being a national market. So the Green Purchase Power Program that EPA generated was very good to recognize renewable energy, but as we go deeper into carbon and carbon offsetting and carbon measurement, it does not apply. So there are a number of problems with applying this test. And as I said, Green E, a number of our clients are getting Green E RECs, and they are receiving Green E certificates for tracking, and they are nothing more than a grocery list. So you might as well flip it over and use it for that, because it's not tracking back to the facility. Next slide, please. So, and once again, we are talking about climate neutral now. We're just in full disclosure, a reviewer for them. They require a third-party review. So, and this is direct reporting. So we're ISO 14001 lead auditors. We're listed on the Climate Neutral Now list as a resource company. We are also a PRI resource company, and we also help companies align to SDG 13. Currently, non-actors are not allowed to report to the SDGs. The UN is in process of setting up a program for that, but anybody that's claiming alignment or reporting to as yet, there is no program for that. So next slide, please. So let's take a look at ISO and consumption based. And ISO requires a market base, right? So what is your electrical market? It's controlled by the state or province. And that's true across most countries globally. You can actually take a deep dive here just in the US and look at those. If I have an electric bill in Indiana, it's controlled by Indiana. That's pricing and a whole bunch of other stuff that goes into it. So that's your market. Just to make this slide very efficient. So you've got to look at RECs that are in your market, or eGrid, or at the most largest expanse, your Nerc grid. So next slide, please. So here are basically some of the three primary grids that we're talking about. There's the Eastern grid, the Western grid, and then the Texas grid. So they do not intermix. You cannot buy electricity from Texas in New York or Chicago or anywhere else. There's a bunch of issues with interconnectivity. So on a larger scale, here's what the three major grids are in the United States. Next slide, please. And now we're going to take a look at the Nerc grids. And these actually break down into areas where power can be translated from one grid to another. So these are where you get power balancing and other things occurring from supply to demand and supply demand changes. So that's where you can actually look at the rec markets and start looking at where you can buy from. If you see, Texas is on its own. And that's where we're seeing the majority of secondary recs being sold into the marketplace for corporate compliance. Please show me how you connect Texas to your facility in New York or Chicago or Boston or Florida. Next grid. Next slide, please. And then now we'll take a look at a little deeper dive is the e-grids. So if you're buying recs in the e-grid, right, and you're using those to reduce your carbon footprint, you also have the possibility of generating a carbon offset project. And that's going to depend strictly upon the number of, well, let's call it megawatt hours that you're in using. So we actually can bundle projects all together so they don't, an individual facility doesn't stand alone. For example, we have a client in Texas that's got 29 facilities. They're doing 100% renewable, and they're actually generating a carbon offset project to the tune of $770,000 a year in income. So just as a quick example. Next slide, please. So let's talk about how that's done, right? So CDM 00091 is energy efficiency and fuel switching, right? So you're switching from grid power to renewable power by having the RECs in the local e-grid. So basically you're able to clean the electrons that are floating through the grid as your power usage by having the environmental attributes or the REC assigned to you through either a VPPA or a PPA or an unbundled PPA, whichever term you want to look at. We actually have some people that are buying them on the spot market, but that allows you to generate a carbon offset project. And the math is very simple on it. It's, as my example alluded earlier, 520 grams of carbon in Chicago versus 10 grams of carbon for renewable. And by the way, electrifying buildings as 100% electricity in Chicago is actually more polluting than using natural gas. So it's an interesting side note. Next slide, please. So a REC can become a carbon offset. It needs scale, right? As in how many megawatt hours. And we look at 150,000 megawatt hours as sort of a base. We can look at, 100,000 or 60,000, but the cost to generate the offset goes up. So there's where scale comes into play. And you can also use combined heat and power, right? Or chip systems and fuel switching, which is huge. So you're getting your steam as well as your electricity from burning natural gas or renewable natural gas. Both of those generate carbon offset projects. And then you need to be able to measure and register these with a UN certified carbon registry, of which currently it's Vera, gold standard, and the UN platform, carbon offset platform, which is for least developed countries. So there are a number of other ones out there. I would be checking with the UN to see if they've been admitted or not admitted, and we'll see if the SEC includes them or excludes them. But that's all part of this regulation that we're talking about. Next slide, please. And here's our panelists.
Okay, thank you, George. Appreciate it very much. If you have a question, we recommend that you type it into the Q&A section. Click on the Q&A button at the bottom of your screen and type it in there, and we will ask it for you. But Justin, I'm going to kind of follow on that question that was about sovereignty. The SEC has a long history of rules like this, and there may be litigation around this, but will the rule, assuming the rule is changed and modified some, and then it will take effect, or will it be on hold during litigation? I mean, what is the typical history been on SEC rules, and if it's challenged on topics like that?
That's a good question, Paul. I can't speak to every instance, but I believe that with respect to the the conflict minerals rule, even during a period of lengthy litigation, which I think was about 4 years in that case, as it wound its way through the litigation, companies were required to continue to provide disclosures, notwithstanding the fact that ultimately, the rule was struck down as unconstitutional. So there is a possibility that if adopted, companies would have to make detailed disclosures even while litigation is ongoing. Would not surprise me at all that the rule is adopted, but that there is vigorous litigation and that it's sort of hewed down and sort of sculpted a little bit more narrowly. But I do think that, and I believe strongly that we're on a trajectory that is going to be very hard for opponents to turn around, just because, as I mentioned in my response to the question, there are such powerful market forces that are influencing the discussion. And I think those, far more than any regulation, are going to continue to incentivize companies to be looking carefully at these kinds of disclosures out of their own self-interest.
Yeah, as
Maybe
I
I could-
understand that market force, the investors are demanding this, and they almost welcome the SEC to step in to try to standardize some of these disclosures. And that brings me to a question I wanted to ask Spencer and George. So if I'm a real estate company and I'm already following LEED or GRESB or trying to make my green claims under them, am I going to be compliant under these new rules or not?
So Paul, I'm going to let George answer that question, but I'm going to jump in for 1 sec on Manuel's question because he may have misinterpreted something I said. There is no one defaulting to the UN on anything. What we tried to communicate is that we expect an ISO standard to be the standard. And if someone's going to make a claim to a UN Sustainable Development Goal, they'll be required to report to the UN, that it's a UN program. But reporting to an ISO standard, the EPA requires numerous ISO standards already. Building codes are ANSI standards. Our largest banks are reporting to Basel standards. Right? External international standards are nothing new. We're not giving up any sovereignty by saying this is the standard to which we're going to require reporting. That's very common practice.
And Paul, to your question, if you are doing any of the green building rating systems and GRESB or any of the third-party reporting, you're not going to be able to get away with using those. Those most likely will not be accepted. And the way the rule is looking, it's looking, as Spencer highlighted, it's going to be ISO, and we're betting 90% on ISO just with all the research we've done. And then we also have corporate GHG as a possibility. It's under update. And we just got off of a call with a US company that has assets in the EU, actually in Great Britain, and they're requiring that you report under BSI's PAS 2060. So that's part of our doing third-party due diligence. So we had to break those out and take a look at those for attestation on underneath PAS 2060.
Okay, thank you, David.
Yeah, thanks, Paul. So Justin, I want to jump back to you for a second. As a litigator, I think about liabilities and risks and things along those lines. And obviously, you think SEC rule, and you initially think, oh, public companies, and we've learned that this is going to be a lot more, far-reaching. What is the potential for private companies to face liability if the proposed rule is adopted?
Sure, David. So, I think Scope 3 comes to mind, right? Because Scope 3 is going to draw within its ambit all sorts of upstream and downstream companies, whether public or private. And so if you think of an issuer with a Scope 3 obligation, they could be looking to a supplier of a small component that's a private company. And if that private company, obviously, I think to state the obvious, if they're clearly engaged in some kind of scheme with the purchasing company, in other words, the public company, then that's going to create liability for the private company as well. So I think the effect of the rule will be to extend liability potentially to private companies as well, depending on the nature of their conduct and, of course, their knowing participation in bad conduct if it amounts to that. I think there'll be some interesting questions about aiding and abetting liability by private companies who provide data to public issuers seeking Scope 3 information.
Thanks, Justin. I would expect you would probably, we're going to start seeing a lot more contractual provisions and agreements between the companies then dealing with cross indemnities and things like that for environmental disclosures.
Absolutely, that is definitely likely. The other thing we didn't touch on, obviously, is the private securities litigation bar. Plaintiffs bar are going to be vigorously looking for new opportunities. This is an incredible boon for that bar, and they will be vigorously pursuing those opportunities.
Great, thank you, Justin. George, Spencer, the proposed rule, by anyone's definition, seems to create significant burdens and costs on industry. Is there potential for the efficient use of like big data analytics and artificial intelligence to reduce those costs? And are there any steps companies have already taken in that direction?
Spencer, I'll let you have a whack at it first, and then I'll follow up.
Sure. Technology always adds efficiency once we develop the right technology. The first wave of reporting and developing environmental product disclosures and getting an actual regulatory compliant level information, there's no way to really make that incredibly efficient. So the next couple of years, there's going to be a cost burden. Once that data flow has been established, then there are firms like George's that have the technology to start streamlining that data and making it simpler. In terms of AI and machine learning, there are lots of uses for predictive kind of black box econometrics, but regulatory reporting is probably not the ideal context for them.
And here, I'll follow up with the fact that we've reviewed a lot of the software programs out there with clients at this point, and a lot of them are using guest averages, national averages, just a whole bunch of stuff that doesn't align with anything. And so I would tell you to be very cautious on what you're buying or relying on, because we're doing attestation on 3 companies now, on several of theirs, and the software is wrong, right? When we look into what the metrics are, so their reporting is off. And they're only reporting to GRES, but that's okay. It's the wrong software. So we are seeing that happen all the time. And as far as big data, big analytics, we were part of the IBM Green Planet. It's just not going to work. We implemented that in 27 cities across the United States, and we saw no significant changes or anything else that came out of it.
Great,
If the recording, if I may, Dave, if the reporting doesn't begin until 2023 or 2024, what should we be doing now? If you're going to be a company that's either in the scope 1 and 2, or even in the scope 3 supply chain, what do you need to start doing now? And from Spencer, George, or even Justin, from a legal standpoint, I mean, what do people on this call need to be doing today?
We're finding, Paul, I'll jump on this real quick. We're finding that companies that have started doing some reporting, right, have started using Energy Star Portfolio Manager, which, by the way, only gives you scope 3, and it's a very partial amount of scope 3 calculation. It's not scope 1 or 2. We're seeing companies ask the question, what else is included, right? So they're already starting to look around, because your scope 1 and 2 includes a number of things that you would not normally think of. It's not just fuels, it's recycling, it's everything. Think about what you own in that company, the tables, the chairs, laptops, all of those have a carbon footprint and fall into that initial ISO baseline audit. Refrigerants are a big one.
Well, maybe add briefly, and I'll let Justin, if he wants to address the legal A couple of things specifically firms should start doing to prepare. If you manufacture or deliver a product or service to public firms, they're going to be requiring you to document your scope 3 or your scope 1 and 2 for their scope 3. So start looking at environmental product declarations. We mentioned earlier the GSA is already requiring them for concrete, asphalt. That's going to increase. There are tariffs going into the EU for some of those. If you are in a large asset-focused business like real estate or infrastructure, there are ways that firms can take this compliance cost and turn it into a revenue center by properly developing carbon offsets. So there are different strategies you can look at with some guidance to really start getting ready for what is going to be a structural change.
Guys, if we
Justin, did you have any? Okay, sorry.
just very quickly in 10 seconds, we're a minute over, I'll just say that, I think taking a good close look at the rule, consulting with counsel and outside auditors and getting ready, as well as consultants, obviously, like George and Spencer, is going to be time very well spent, because I think there'll be a lot of kicking and screaming. I think there'll be a battle royale when it comes to litigation, but I do think it's coming, and in many ways it's already here. So people should get prepared.
Yeah. Great, thank you, everyone. We appreciate Justin, Spencer, George, your insights, and we are just over the hour, so this is going to conclude today's webinar. Remember to keep an eye out for our follow-up email, which will include links to the program materials, recording, and CLE survey. And finally, if we did not get to your question, we will do our best to send you a response via email. In the meantime, feel free to reach out to us or any of the presenters with questions, and we will glad to get back to you. Thank you, everyone. We appreciate your time.
Thank you.
Thanks.
Take care.